Good evening to all of you present here. A small and great welcome makes a merry feast. Now I request Senior Advocate Mr. Isaac Mohanlal, the President MMBA, to deliver the welcome address.
Good evening to all of you. Honorable Mr. Justice SATHIsh Kumar, Judge of this Honorable Court, Mr. Saravana Kumar, the Secretary, Office Bearers and the Executive Committee members of MMBA, our learned senior advocates, Mr. Venkatramana, retired district judge, a former principal of Madurai Law College, Mr. Thangapandian, other senior advocates, junior members of the bar, ladies and gentlemen. It gives me immense pleasure to welcome one of the most affectionate judges of this Honorable Court, Honorable Mr. Justice SATHIsh Kumar, amidst us this evening. Why I say that His Lordship Justice SATHIsh Kumar is very affectionate to us is not because he is lovely. He is affectionate for various other reasons. Because now we experience in our day-to-day life that we have varieties of judges, various kinds of justices. Some are very stern, some are a little timorous, some are fast, some are slow. But we find in Justice SATHIsh Kumar a combination of very rare, beautiful qualities of a judge. There's a famous statement by one of the justices of the US Supreme Court, Justice Earl Warren, very beautifully said, "Our judges are not monks or scientists, but participants in the living stream of our national life, steering the law between the danger of rigidity on the one hand and of formlessness on the other. Our system faces no theoretical dilemma, but a single continuous problem: how to apply ever-changing conditions, the never-changing principles of freedom." And in our experience, we would certainly vouch that the disposition of His Lordship Justice SATHIsh Kumar squarely fits into this definition of a good judge. Every day from morning to evening, you have been seeing that a man who is sitting with such a smiling face, occasionally cracking very intrinsic jokes, which we would take a little longer time to understand and laugh. And at the same time, a judge who is of sterner stuff, calling the stenographer and dictating the judgment on the spot. And you would be amazed to see very often that the points that even we might not have stressed much, but that would find a place in the judgment. And a very practical, very bar-friendly judge. It is good that we have him amidst us. But it was a matter of little surprise when we asked him that, please come and deliver a talk on a subject of your choice. Pat came the reply, the new criminal laws, the 3 criminal laws. But we don't have much acquaintance with the new laws because we are struggling between the old and the new, because we are all accustomed to the old 1860 laws. And it is good that we hear from the bench an overview of the new laws. It would be always beneficial for us. And I have a request also to make. Justice SATHIsh Kumar, I have a request on behalf of the bar. Over the past 3 months sitting here as a judge of this Honorable Court, your Lordship might have come across situations where there are exaltations and debilitations at the bar. Bar might be excelling in some areas and would be lacking in certain other areas. And it would be better if we come to know of what is passing on in the judge's mind about the bar's performance over the past 3 months, so that we will be in a position to rectify or correct ourselves wherever we commit the mistakes. And it would be very beneficial for the junior members of the bar. In fact, if we trace the history of the British bar as well as even the Bombay bar, the bench and the bar would very often interact, so that they would always set off these differences. Sometimes judges may require something or expect something from the bar, but the bar is not living up to that expectation. Because at the end of the day, judges are interested in delivering the judgment. They are interested in disposal of the cases. Bar can better serve if they facilitate the disposal of the cases. At times we fail. because we may come with a particular mindset and the judges would be expecting something differently from us. Therefore, it is always good that the bar and the bench meet often, share the good and the bad. And I would request on behalf of the bar, in the course of your lordship's talk, please enlighten us and what are the areas where the bar needs some kind of improvement. And with these few words, I invite each and everyone to this beautiful moment and beautiful function, which is absolutely academic. Thank you so much.
Thank you, sir, for the welcome address. Now I request Senior Advocate Mr. Isaac Mohanlal, the President MMBA, to present the memento to our Chief Guest, Hon'ble Mr. Justice N. Sathish Kumar, as a token of love. Thank you, sir. Thank you, Lordship. Now I request Honorable Mr. Justice N. Sathish Kumar to enlighten the gathering in the topic, the BHARATIYA NAGARIK SURAKSHA SANHITA 2023 A View.
Mr. Isaac Mohanlal, the President of the MBA, and Saravanan, Secretary, and all the senior advocates present here, and my dear friends, the future of this institutions, young generation of lawyers present here. I'm very happy to be here for giving me an opportunity to share my thoughts with regard to the new act. In fact, it's gave me a chance to just refresh myself to the new act. You know that judges find timing is very, very difficult. We have no time to read nowadays because of a lot of the work accumulations. This gave me an opportunity to just go through some provisions. This is only, I am not addressing on any critical analysis of the new provision of law. Just I am bringing to the notice of the changes affected in the new law. What are the nature of the changes affected in the new law? It will be useful for the young lawyers, particularly young lawyers who are practicing in criminal side. As far as your president request about the opinion about the bar, now honestly I am telling you, the Madurai, there are few sections of lawyers I've seen. Don't mistake me. There are very creamy section of lawyer. They are excelling well, both in civil side, criminal side, writ side. But as I understood, the creamy section is only one part. But majority, they want to always try to depend on the 226 jurisdiction as mandamus jurisdiction. That has to be avoided somewhere else. They don't understand how the 226 would be exercised. What are the issues will arise in the writ petitions? The problem is that they're not even in a position to consult others, to take opinion from the seniors. They just like, as a matter of right, some of them feel this is their right to file any petition as a writ petition and get an orders as a matter of right. That attitude really is not good for an institution. See, only when the bar is vibrant, is knowledgeable, the institution will survive. If the bar is not cooperative or not supportive, is not educative, is not having such a knowledge, then how can you say that the institution will survive itself? The bench cannot survive on its own unless it is properly assisted by the vibrant lawyers. The vibrant lawyers includes knowledge-wise, integrity and honesty. Their interest, at the most, their interest to see that the institution survives forever. But young lawyers, majority, I do not know what is the background for that. Whether they understood the legal issue, or they think that this is only profession for survival. Then the problem has to be addressed. I do not know how it has to be addressed because keeping in view of the large group of members coming every year. Of course, the young lawyers, the creamy section of lawyers, they're doing a wonderful job. They improved a lot. Even I used to say, even I compared young lawyers here, they are more than the lawyers practicing in principal bench also. Because we have seen in our experience. So those group only will have to take interest of the others to some or other to bring to the mainstream. For example, see, yesterday I come across a writ petition. The motor accident claim. The case is that tipper lorry hit the bike in which her husband was traveling. As a result, he succumbed to injuries. That was the case. He files a 226 application, writ petition for compensation. When the judge tried to explain to the lawyer, they may not be in a position to receive that properly. That is the problem, some of the lawyers. Similarly, just like that, I told them, why many matters, repudiation of the claim, insurance claim on the basis of disputed facts. Most of the people, they file a writ petition here. What is the purpose? They should understand reality. This is the legal position. They should go to the forum where they can agitate properly. So this is the small area. I think the young lawyers should be addressed in this also. This is the only issue. Otherwise, a creamy section as identified, we have identified a certain section of lawyers here. They are a class, keep it up, and the future of the institutional surveys depends upon your caliber and strength. So with this, now we go to the subject. Okay. So you know all the amendment. As far as I am concerned, except some procedural changes, most of the changes made in this procedure code. As far as the old Evidence Act is concerned, there was no much change. Except one or two omission in the new act, there is no change in the Evidence Act. As far as the procedure code, there are a lot of changes. The changes with regard to the time limit has been made in a lot of sections, time frame has been brought in a lot of sections. And major changes, some of the changes with regard to the victim-centric, women-centric, the compensation aspects, and the nature of the investigation, how the investigation to be proceeded. The investigations to be only on the basis of the electronic devices. So all these changes have been brought in. So now I'll give you the bird's eye view of some of the changes right from the beginning. So this audio, video, electronic means is also included in the definition class, section 2. Use of communication device for the purpose of video conferencing, identification, search and seizure, etc. Why am I emphasizing this? This has some significance. These are all the documents used for the purpose of recording any statements, recording any search, seizure, etc. It comes within the purview of the electronic records. So it has to be proved in the manner known to law, as mandated under the now new act, new Evidence Act, SATHIsh Sanhita. So now electronic communications included in section 211I, the communications through mobile phone, telephone, wireless, camera, video players, etc. assumes very, very significance. It has to be used in every investigation now. So this is the important changes even brought in the definition itself. Now, the classification of the codes. You know that previously as per the code, there were 4 categories codes. Right from second class magistrate. Of course, the second class magistrate has been dispensed in Tamil Nadu. First class judicial magistrate, chief judicial magistrate, assistant sessions court, additional sessions court, then Sessions Court. Now, and Metropolitan Magistrates. Now, Section 6 of the Act does away with the metropolitan concept. The Metropolitan Magistrates Court have been taken away, removed by new enactment. You may ask, now what about the existing courts? But you have no other go. For pending cases, you have to retain the existing court also, metropolitan courts. We have section 531 of the new act. As long as the old cases are pending, for the purpose of trial of those cases, all the metropolitan magistrate courts also to be retained. But only thing is there must be some powers has been conferred further to proceed under the new act. They should be treated as a JM as per the new act, not a metropolitan magistrates courts. Now the main provisions, now it's also to be noted that by introducing the electronic evidence, electronic equipments right from the investigation stage, it's extended up to the trial also. Now the trial also by conducted, trials, enquiries and proceedings may be held electronically. That is a specific section introduced into the new act, the section 530 of the BNSS Act. So trial also can be held under electronic means. Now the power of the judicial magistrate is enhanced to impose the fine is enhanced to 50,000. Initially 10,000 alone has been, the power has been given to the judicial magistrate. My brother Bharat has come. Now power has been enhanced. The power to impose the fine up to 50,000 has been enhanced to the vested with the judicial magistrate courts. We have the amendment. The other, unlike a default rule, those days there is a multiple offences. There are various offences and accused has been found guilty in the various offences. Whether the punishment should run as consequently or concurrently, there is no discretion. It must be directed specifically as per the existing code, the old code. Unless it is directed by the magistrate, it should run concurrently. Now, it is not like that. The default rule like existed originally not taken away. Now there must be specific direction. Discretion of the magistrate now. Discretion has to be, he has to pass an order by using a discretion by taking note of the gravity of the offence. Whether the punishments for various offences should run concurrently or consequently, he has to pass an order. This is a significant change as made while imposing the sentence by the magistrates. Now you know the prosecution agencies, similarly director of prosecution must be there in every district, and with regard to arrest, now which deals with, originally it was in section 41 capital A of CRPC. Now it is in section 35 subclass 3 to section 2(6) of the BNSS, and section 35(7) bars the arrest of the infirm or a person of senior citizen when the offence is punishable with less than 3 years. There cannot be arrest. You can't say that there cannot be arrest. Arrest can be made, but such arrest cannot be made only with the previous permission of the DSP. There must be permission. This is mandatory to effect any arrest of the person. This is provided under section 35A. And as we were all discussing in the other room, now section 43 enables the police, authorizes the police to handcuffs to effect arrest in cases of habitual offenders, offenders committing organized crimes and terrorist offences, etc. So earlier, because of apex court judgment, order has to be obtained by the magistrate court to use the any handcuff, etc. Now the police have a discretion in certain category of the offences that they can use the handcuff. This is one of the changes made in the new act. Then other aspect, the proclamation with regard to absconding accused, old code, only the proclamation is issued, the property will be attached, then there is no other provision to conduct the trial against him in the absence. Now the trial is permitted as against such accused in absentia. Trial may be conducted in absentia against the proclaimed offender, and even any judgment can be pronounced against the judge. So, challenge that finding, the accused has to appear before the trial court. Previously, the fair trial concept, trial should be conducted in the presence of the accused, that has been taken away. So, to challenge that, the appeal, he has to appear before the appellate court, and the judgment, he has to appear before the appellate court. Further, he has to challenge that the judgment passed against him in a trial held in absentia. He should challenge within a period of 3 years. Limitation is also fixed. Suppose somebody is absconding, residing somewhere else, is avoiding the trial here, he has to come before the court, either to participate or even in the event the judgment is passed against him, he has to challenge in the manner known within a period of 3 years. This is one of the important provisions have been incorporated in the section 356 of BNSS. And similarly, evidence of the co-accused would be admissible against the proclaimed offender. Special provision is built in way of the explanation to section 24 of the BHARATIYA NAGARIK Adhiniyam. So previously, the evidence of the co-accused will be considered against other accused. Now, in view of these provisions, it's made it admissible against a absconding accused. This is a significant change has been made in this provision. And with regard to the proceeds of crime, police can obtain orders of attachment from the jurisdictional court straight away. Previously, they used to find a very lot of difficulty. They have to invoke all the old ordinance, Criminal Law Amendment 1941 or something 37. They'll have to go there, they'll get a GO, then they'll get it confirmed by the district court. Now, it's made very, very easy for them. They can seek an attachment of the property. There is a provision under section 107 of BNSS. Now the investigation, you know that. Now the zero FIR concept has been introduced. Irrespective of the area, you can give information electronically. Once the information is provided electronically, it should be signed by the person, the informant, within a period of 3 days. 3 days time is given to him to sign it. Preliminary inquiry is also now provided, where the offence alleged is punishable for 3 years or more, but less than 7 years. Preliminary inquiry is conducted with the permission of the DSP. Preliminary inquiry should be conducted within a period of 14 days. This is the provisions made under section 173. And victim or the informant must be furnished with a free copy of the FIR, section 173 subclass 2. The other significant changes brought on the investigation against the public servant in powers of investigation, 175 subclass 4. The magistrate can order investigation against the public servant alleging the commission of offence in the course of discharge of his duties only upon the receiving of the report from his superior officer. The public servants ought to be prosecuted. Any complaint is filed in the magistrate court. He cannot take cognizance. He cannot deal with the complaint. First, he has to seek an opinion from his superior. That they are not only the opinion, the report from the superior officer, explanation also to be sought from the public officer against whom the prosecution be sought to be initiated. So this is one protection is given to the public servant. Then statements given to the police is maybe recorded by audio, video, electronic means. It's not necessary that it should be reduced into writing, as they used to do it under section 161. But they have to make it as they can record it by audio, video, means, electronic means. Then final report in sexual offences or offence against women should be filed within 2 months from the date of registration of FIR. Time limits, specific time limit is fixed. As far as the sexual offences or offences against women, the maximum time limit is 2 months. Then the other important aspect, now the IO is required to communicate the progress of investigation to the victim or information within 90 days from the date of FIR. What was the nature of the investigations? How the investigation is proceeding should be intimated to the victim then and there. This is made as compulsory now. So this is the victim-centric approach has been introduced in this new act. Then adequate copies of final report and supporting documents while filing the same with the court. Copy should be given to the accused within 14 days of his appearance or production as contained in section 230. When the accused is appeared before the court, the copies and documents relied upon by the prosecution should be furnished to the accused within 14 days. Time limit has been fixed as per section 230 of BNSS. Then further investigations also time is fixed now. Further investigation should be completed within 90 days. Of course, it can be extended with the permission of the concerned court. Not beyond the period. There must be only reasonable period could be extended. Now, the remand as per the police custody. Section 187 deals with first and subsequent remands. See, you all know that the Anupam Kulkarni case, the apex court has held that police custody could be given within first 15 days, during the first 15 days of the custody. Now, that judgment has been diluted, and now it is this provision itself is introduced in section 187. Now, they can be remanded for a period of not exceeding 50 days on the whole or in part, or at any time during the initial 40 days or 60 days out of the total detention period of 60 or 90 days as the case may be. So now, even after 15 days of the initial custody, police custody can be given. Even the entire period of 15 days itself can be given to the police custody can be given. Now this provision has been made. It's all taking note of the hardcore criminals, nature of the crime that which has an international ramification across the state. So this is all taken into consideration. That's what the power has been, time has been extended. And the remand is also now possible, can be extended by audio, video, electronic means. Remand can be made either to police or judicial custody. Now, the law laid down by the apex court with regard to the house arrest in Gautam Navalka case, all remember 2022 13 SCC 542 has been diluted totally. That provision has been taken away. The concept of the house arrest is totally taken away. Though in the previous code is also there was no provision, but Supreme Court has introduced that, legislated in the sense, in that judgment, Gautam Navalka. That has been taken away with this. They removed it. They said that custody can be either in the police custody or judicial custody. The concept of the house arrest totally is taken away in this provision. As far as the taking of cognizance under section, originally under section 190 of CRPC, now is a 210. The provision retains the same three methods of taking cognizance, that is on a complaint, on a police report, or on the knowledge of the magistrate. As far as the private complaint, one novel procedure is also introduced now. Cognizance on a complaint, on a private complaint, it cannot be taken unless the accused is afforded an opportunity of being heard. The proviso to section 223 is made. So this is also one way it's a good opportunity to the accused person to defend him. See, some existing practice we know that the person may not even know what is happening behind him. Somebody goes and files some complaint before the judicial magistrate, and straight away see that it's either referred to the magistrate under section 156. The moment it's referred under 156, the FIR will be, he may not even know. Once FIR is filed against him, there ends the matter. He has to undergo the several consequences. So to avoid, similarly this private case also. What is behind him, what is happening, he may not know what is happening behind back. Summons will be issued automatically. One day, only once the summons issued from the magistrate court, only he will realize the court has taken a cognizance against him for the particular offence. So that will be avoided in these provisions. He will know what is happening against him. He has an opportunity to defend that in the earlier point of time. This is the provision is made in 223 proviso. Similarly, cognizance of complaint against the public servant alleging commission of offences during the discharge of his duties cannot be taken cognizance unless report is obtained from the superior officer and public servant is given an opportunity to submit his explanation. This provision is also applicable to the protection, is also applicable during the investigation stage also, section 175. So now the report is mandatory from superior officer and also the explanation to take cognizance in the public in respect of the offence said to have been committed during his, while discharging his official duties. So these are all some safeguards have been made with regard to the taking of cognizance. And supply of copies, 14 days time limit is fixed. Copies must be supplied to the victim and the accused. So it is also victim centric. Previously, there is no provision to provide a copies to victim. They will have to go and engage a lawyer and file an application to get all the copies. Now, this is mandatory that all the copies should be furnished to the victim as well as accused within 14 days from the date of appearance or production of the accused. Section 230. Copies also may be supplied electronically. Suppose accused well versed in electronics, all the copies can be mailed. There is a provision, third provision to section 230. And if the documents are voluminous, he may be permitted to inspect it through the advocate. That is already a provision is there. Now other one important amendment is, introduction is made. Accused can file an application. Previously there was no such provision for seek a discharge in a district court, sessions court. Now sessions court has to decide the existing court whether the charges have been made out or not, whether it's a fit to proceed against him. Now he can file an application for discharge within a period from 60 days from the date of committal. In a warrant case, also similarly 60 days time is given, but limitations start from the date of supply of copies. So the 60 days time stipulated to prevent a delay. So every accused has to exercise this right to file a discharge application within a period of 60 days from the date of committal. They need not wait one by one. What will happen in the present practice? There are 10 accused. A 9 will file the discharge petition first. you will will drag that issue for 6 months. After dismissal, he will file a revision. Thereafter, one by one, every accused will start filing the discharge applications. So, to avoid all the delay in practice and to prevent such a delay in practice by the accused, this provision has been introduced in this new act. As far as the sessions trial concerned, charges must be framed within 60 days from the date of the first hearing on the charge. 60 days, time limit is fixed. Charge may be read out to the accused either physically or through audio, video, electronics. Now suppose the accused is not in a position, he has not been produced to the court, that will not deter the court to frame the charges. Now we have a video conferencing everywhere, you are connected to all the prisons. The judge can immediately proceed framing the charges, video conferencing. This is our great advantage to minimize the delay. And the evidence of the witness also be recorded electronically under section 254 of 1. And judgment, the 30 days from the date of completion of arguments. And maximum it could be extended by another 45 days for in the criminal cases. So maximum time limit for pronouncing a judgment is 45 days. This has been 258, introduced in section 258 by 1. Then, as I already said, the charges should be framed within 60 days from the date of first hearing. So, examination of witness also may be done. Accused also be examined electronically. But witness also be done electronically at a designated place as per section 265. And the defense witness also, similar provisions is made. So, designated place, we also identify, we denied. We also framed a rule, video conferencing rules. High Court video conferencing rules. We also notified certain areas that what are the designated place also. So that from that places, the witnesses straight away, they need not even come to the courts. With the help of the facilitator, as we have framed the rules, video conferencing rules, they can be examined. That provision is made in this. Now, the evidence must be taken in the presence of the accused or his advocate, recorded through AV electronic means at the designated place. As I said, designated place is notified in our rules. See, where the evidence of the accused is recorded electronically and he is in custody, signature of the accused shall be taken within 72 hours of such examination. So, time gap is also given to get his signature in the recorded statements. So now, as the Civil Procedure Code, one provision has been introduced in section 330, which requires the accused to admit or deny the genuineness of the documents supplied by the prosecution in the final report. So admission and denial shall be within 30 days from the date of supply. So admission and denial is made. If the genuineness is not disputed, the document may be read in evidence without further proof of signature of the person. So as the procedure followed in civil procedure, now the accused is required to either to admit or deny the certain document, genuineness of the document. If you don't deny the documents can be admitted now. Without formal proof of those documents, the document can be admitted. This is one of the provisions made under section 330. Then now, as far as the report given by the public servants, some of the public servants would have died, some would have retired, their whereabouts has not been known. To meet out that scenario, that situation, now it is made provisions in section 336. Those reports can be proved by the successor officer or the officer holding office at the time of giving evidence. The immediate successor or any other person is working with him or under him, he can prove that certificate or report given by his predecessor. Section 49. The magistrate has now been expressly empowered to order a person to give us voice samples. You can compel to give the voice samples. Previously, only with regard to what are the samples they used to take. Have anybody idea? Thumb impression, fingerprint, handwriting. Now, voice samples is made as also. They can take samples. They compel the person. So, adjournment is also limited. Now, 2 more adjournments, not more than 2 adjournments should be given as per section 346. Now, 357, victim. As per the victim is the duty to, hospitals were under the duty to provide first aid and medical treatment free of cost. Particularly the victim of rape, gang rape and acid attack. Now it has been extended to all the POXO cases also. POXO victims, treatment should be free of cost. This has been introduced in 397, and state government has to notify the witness protection scheme is also made as mandatory. As on today, the judgments of the Supreme Court, direction given in the Supreme Court in Mahendra Chawla vs. Union of India, holding the field, because my recollections, there is no effective victim scheme notified by the states. Of course, there is some scheme. They all directed only our legal district legal authorities to decide the compensation. There is not. There must be a proper scheme, in my opinion, should be introduced. Till now, without to abide by the judgment of the Apex Court in Mahendra Chawla vs. Union of India. Now the mercy petitions. Now the time limit is set. The petition must be made to the governor, and rejection of the petition, the president within 30 days. And similarly, the power of the government to commute sentence under section 475 been curtailed, and commutation can be done only after the convict serves certain minimum sentence. Suppose a life sentence, a death sentence, it's required now. Yes, we should have undergone the minimum 14 years of sentence. That's power they retain. Otherwise, whims and fancies, the powers have been exercised by the government. Remission has been done. Now, there is a check for this. 475. Similarly, mercy petition also, you can't keep the petition for years together. You will have to exercise that option. The convict has to exercise that option within the period of the particular period. What is the period? 30 days from the rejection. Now, anticipatory bail. There is no anticipatory bail for certain offences. 482. Now, section 482/4 of the new act deals with anticipatory bail. In the cases of rape of victim below 16 years or gang rape of women below 18 years, that there is no anticipatory bail. The court cannot exercise the power to grant anticipatory bail these type of offences. This has been introduced in section 482, subsection 4 of the Act. So, time-bound investigation as against women is introduced. As against the women and POXO offences, investigation should be completed within 2 months from the date of registration of FIR. And provision 21 mandates the trial for sexual offences under section 64 and 74 of BNS. Trial should be held presided by the women judge, but this is not practically possible. This may not be mandatory. So all the pending cases saved under section 531. This is some of the key changes made in the new act. Similarly, the time limit. The victim now includes the guardian or legal heirs of such a victim. This has been introduced now. The previously, the victim includes a person who has suffered any loss or injury by reason of the act or omission for which accused person has been charged. To claim any compensation as a victim, one of the criteria is that accused should have been charged as per the old code. Now that provision has been omitted, irrespective of the fact whether the accused has been charge sheeted or not. They can claim, they come within the ambit of victim, they can claim a compensation, including by the guardian. Now, any cases filed by the women and the victim, unlike previous code, now the case cannot be withdrawn without the consent of the victim. This is a specific provision is made in 360. Before withdrawal of any case, they should be given an opportunity. Previously, what used the government say, APP will say, when file a memo, government inclined to withdraw this, the passed an order, there is the matter. Now it's not so. They should be heard. They are the stakeholder, they should be heard. And various offences against women and child have been made gender neutral in terms of both the victim and the perpetrator. So medical report, previously there was no changes, time limit. Now it should be made within 10 to the 7 days. It's all made. So there are different specific timelines provided in this act. For example, I'll give you the timelines. Where are they? Which sections the time limit is fixed. In original CRPC, section 154 FIR, there was no time limit. Now, under 173, the FIR to be taken on record if informant signs it within 3 days. So, time limit is 3 days. Preliminary inquiry, there was no time limit earlier. There was no concept. Now, inquiry to be conducted within 14 days. 173.3. Daily reports, initiation of the criminal proceedings, police to forward the daily reports in non-cognizable cases. There was no time limit originally. Now, once in 14 days, every report has to be sent to the court. Inquest report should be forwarded within 24 hours now. Previously, there was no time limit. Medical report, medical practitioner to forward the medical examination report without delay as per section 51. As far as the medical examination report relating to the victim of rape, it should be forwarded within 7 days. Search records to be forwarded to the nearest magistrate should be sent but not later than 48 hours. So within 48 hours, all the search, seizure, other documents should go there. Audio, video recording, search and seizure without delay should be equal. So cause notice period for person to appear before any court before the attachment of property, 14 days time. Information on status of investigation to victim within 90 days, they should give copies. Information with regard to the investigation should be furnished to the victim. Further investigation to be completed within 90 days. So these are all the key changes with regard to some of the victim-centric approach and human-centric approach. But at the end of the day, all this new enactment will always depend upon the investigation. So most of the sections is made to make they make the investigation very transparent. They made it as mandatory to record search and seizure with regard to the observation method, the place of occurrence. The law mandate that all should be recorded by electronic means. Now the question will arise, how this could be achieved without a proper infrastructure developed by the concerned the governments in this matter. So practically we have seen there must be a sophisticated systems to be given to the investigation agency. Is there any such things that have happened here? Whether they have been given any investigative tools is a matter of concern. Then second aspect is a authenticity of the records, preservation of the records. how to maintain the documents, how to preserve the electronic records, how to take the printouts. Now, the other law, they introduced that to file electronic records, they allowed not only with the certificate as mandated under new act, old act 65B, now what is a comparative table, I do not know, section. Not only with the certificate, but they'll also to annex the hash value certificate. Then how many of them expert in getting that hash value certificate, how they train, these are all the questions will have to be addressed later. But otherwise, the introduction of this electronic evidence in the investigation stage itself is actually is a benefit to the accused as well as the is a balancing act. There cannot be any fabrication. Right from the investigation, right from the observation, magazine, search and seizure, if electronic evidence is used, the maximum filing of false cases can be avoided. This is one benefit. But to achieve those things, unless there are the sophisticated kits are given to the investigation officer, it takes some time. This is my personal opinion. Everything has been introduced. Then who has to take care of it? That is one of the main problem we are able to face in this investigation. And there must be a proper training. As the Pratap Singh case, Supreme Court has directed, there must be a separate investigation agency. But the state governments are not implemented, not only in the state government, most of the states, some or other, they are not willing to implement that order. The reasons best known to them. That is also one of the, that will actually, in fact, that will dent the very system itself, investigation agency, very criminal jurisprudence itself. Once the proper investigation has not been done, investigation is compromised, that may lead to allow the culprit to go scot-free, innocent to get caught. This may lead to severe consequences. That aspect has not been addressed properly in my experience I have seen. Because of all the investigations, all the connections happening because of few good investigation officers and some evidence coming before the court, that's what the conviction is happening. Strictly speaking, only on the basis of their investigation, you apply the law, there will be a problem forever. So this is some of the key changes made in the new act. I am not spoken about any critical analysis of this, just I brought the views of the young lawyers, some changes, that's all. For critical analysis and interpretation, it will take some time. Now only the courts have to interpret now. There may be some huge problem also may come, which I expect the problem only in proving the electronic evidence. It will have a serious consequences. See, if one way of interpretation, you accept the interpretation of the full bench of the Supreme Court and Anwar case, the moment if the electronic evidence, certificate has been produced, it has to be admitted as an evidence. That will give some other consequences also. It may allow you to produce the document. Then how to prove the facts? But there is no clarity in that. Because electronic evidence is capable of manipulation. It's easy to manipulate it at any time. It has to be proved like any other document. Then certificate has to be issued by the only expert, notified under the electronic inspector, somebody is notified under, to be notified under the Information Technology Act. How many of the experts have been notified by the government? Then where these people will go and get the certificate? These are all the practical problems we have to face. Then now everything is capable of manipulation, particularly in the social media. Everything can be said. They can mop you, morphing can be done easily. Your voice can be copied. So many things can be. Then how to prove this? This is one of the greatest challenges we will have to face in future. So, my view, in fact, I gave a suggestion also to the ministry also, one of the time. Singapore model is the best model. If you have a chance to read that Singapore electronic evidence, it's one of the best model. They could have copied it simply, as they copied here. Section 65B is just a copy. They copied the Civil Evidence Act of England. By the time it was repealed in England, when they introduced in the year 2000, it's already repealed in England. That has been just copied and they introduced as a new section as Section 65B. There are confusion, one by one. Anwar, the last. Then Parliament attack case, they relied upon. Without certificate, they relied. Then that judgment doubted. Then Anwar came. Now, further confusion is added in the new act. So, these are all the challenges we will have to face. We will have to ponder over. So, you will have to contribute much in interpretation of this law. The youngsters, you will have to see the consequences also. You will have to just think yourself in the person who is facing the problem, particularly in the electronic devices. How the persons will be mapped, how the cyber crimes, cyber law has been taken shape now, cyber attacks. So this is the challenge. Definitely we all to face this system. So any other subject, any other things? I hope I informed you the only changes. With regard to the other subjects, later will come. I'll come after some time. Yes, thank you.
Thank you, Lordship, for enlightening us. Dear members, as we all know, the Sport Committee of MMBA, under its chairman, Advocate Chellapandian, has conducted Justice Cricket League State Level Cricket Tournament, which is scheduled from 19 to 21 of October. Totally 15 teams participated, and members, we are happy to announce that our MMBA team won the first prize under the captainship of Advocate Rajarajan. Now I request Hon'ble Mr. Justice N. SATHISH Kumar to hand over the winning trophy to the team. Thank you, Lordships. The more you practice the art of thankfulness, the more you have to be thankful for. Now I request Advocate Kumar, the Secretary, MMBA, to deliver his vote of thanks.
நண்பர்கள் அனைவருக்கும் மாலை வணக்கம். எமது சங்க அழைப்பை ஏற்று 3 குற்றவியல் சட்டங்களை பற்றி மிகவும் ரத்தின சுருக்கமாக அழகாக பேருரையாற்றி அமைந்திருக்கும் மாண்புமிகு நீதியரசர் சதீஷ்குமார் அவர்களுக்கும் மற்றும் மாண்புமிகு நீதியரசர் பரத சக்கரவர்த்தி அவர்களுக்கும் மற்றும் சங்க தலைவர் அவர்களுக்கும் இந்த 20 ஆண்டு கால மதுரை உயர்நீதிமன்ற சீரியலில் தொடர்ந்து நிகழ்ச்சிகளை நடத்தி கொண்டிருக்கும் நமது சங்க தலைவர் அவர்களுக்கும் மற்றும் நிகழ்ச்சிக்கு வருகை தந்த மதிப்பிற்குரிய மூத்த வழக்கறிஞர் TSR வெங்கட்ராமா சார் அவர்களுக்கும் மற்றும் நண்பர்களுக்கும் திலீப்குமார் மற்றும் அனைத்து நண்பர்களுக்கும் இளைய தலைவர் வழக்கறிஞர்களுக்கும் நன்றியை கூறி நன்றி வணக்கம்.
Thank you, sir.